This is Arkady Frekhtman, a New York City personal injury attorney, and today we're talking about your questions. It's last week tonight with Arkady. We are answering your questions. So let's get to the first question. The first question is from Chili Serrano, and she writes, I fell at a gas station. I was fine, just shocked. A few days go by, then I felt pain. I called to the doctor. It took months to get in. I got in, the doctor said, oh, it's inflammation. No. I call another doctor, a bone doctor. So yesterday I found that I need surgery on my spine. During this time, I'm calling the gas station about filing a claim. At the time of the accident, I made a report. What can I do? So I think with that kind of a scenario, what you should do is contact a local personal injury lawyer. I don't know what city you're in, but definitely contact a local one. If you need help, you could text me, 347-566-9595. I'm happy to do some due diligence and find someone who's good. Perhaps it's somebody that I've worked with in the past or that I know through one of the law organizations. I'm in a lot of law organizations, and then I can help you, and then you can work with that lawyer who will be an excellent trial lawyer and can help you. Remember, it's free of charge, right? So if the lawyer wins money for you, they might take a legal fee, but it'll be much more money. See, dealing with the gas station on your own is very, very dangerous. First of all, you don't even know, right, who the owner of the gas station is. You file a report with a gas station, you could be filing it with an employee. That employee could take that report and just not want to give it to his manager because that might be more paperwork for him. He might just take it and throw it out. How do you know, right? These gas stations are very small, like some of them are mom and pop shops, but sometimes they're franchises where you have the owner of the franchise, but then you also have corporate, and there are many different levels, many different entities, corporate entities that you could potentially sue. So I definitely wouldn't deal with them on your own. The other problem with that is that, you know, even if that gas station sends your report onto the insurance company, you can't really expect them to contact you or to do anything. Remember, they're not your friends. What they're trying to do is protect their interests. They're trying to pay out as little money as possible. So all you're really telling them is you're telling them, oh, I had this fall. Okay, well, what they're gonna do is they're gonna take every possible step to protect themselves from this fall, to say, oh, maybe you fell because it was your own fault. Maybe you won't even file a claim, so let's just file it away. We have whatever period of time, like in New York, you have 3 years against a private entity, so they might just be sitting on it, waiting, hoping the 3 years go by and you don't do anything, right? So definitely contact a lawyer, especially if you're gonna need spine surgery. That's so serious. There wasn't any indication as to how the incident happened, but I'm assuming there's some sort of liability that you think the gas station did something wrong. Maybe there was like a puddle or some kind of defective condition like cracked cement or a hole, but you could talk about that with the attorney. But I hope that's helpful. But definitely don't, sit back and think that the gas station is going to do anything, because they're just not. Okay. The next question comes from Circumnavigate, and it is, are jury decisions influenced by the race of the plaintiff, specifically discrimination against Middle Eastern people? Well, I think that's an interesting question. I mean, of course, when you deal with a jury, what you're really dealing with are just, in New York, we have 6 jurors plus 2 alternates. So we have 8 jurors in a civil lawsuit, right? In New York State, including New York City, though it works the same way. We have 6. So it's just 6 people from the community, right? So some of them could be, not racist. Some of them could be racist and could discriminate against you. So I think the important thing that you want to do is your lawyer should be well-versed in the art of voir dire, jury selection. They should be able to connect with the jurors, speak with the jurors, let the jurors do most of the talking, and then the lawyer should be listening very carefully. And what's really good is for one lawyer to be speaking and doing the voir dire and another lawyer to be in there just taking notes, right? Because that way everything is caught. Because if you're actively engaging with jurors, if you're speaking to them, especially like a panel, because remember, when you're speaking to it, you might be speaking to like 20 people all at once. It's hard to speak with people and remember everything that everyone said. It's, some people just get shy, speaking to people by itself. So that's kind of like an art form. So, but yeah, in terms of your question, I mean, if you feel like somebody might be discriminatory against a specific group of people, like against Middle Eastern people, one of the ways to deal with that is just to ask them, you just tell them, I mean, you want to be vulnerable, you want to be honest. One of the themes that I always bring up in jury selection is brutal honesty. If the jurors will be brutally honest with me, then I will be brutally honest with them. And if I have any problems in my case, or I have any issues, like the race of my client, or maybe that my client is very old, or maybe that my client had a prior accident, any kind of issue at all, just bring it up, right? Front it. It's known as fronting. You want to front the issue. So tell them, yeah, my client is Middle Eastern. Does anyone have a problem with that? I remember we had a case with a Middle Eastern client, and for whatever reason, the judge was really aggressive towards him, but the jurors, I guess, didn't like that, and they wanted to protect him. So he ended up getting a $300,000 verdict on kind of like a soft tissue pain management case in a conservative venue in upstate New York with this Middle Eastern client. So I think I don't think you have to worry about it. And now there's another thing that the courts are trying to do. In the jury instructions, they added a section about implicit bias, right? Like a hidden bias. And they talk about stereotypes. They talk about your feelings towards groups of people. So that's now in the jury instructions. And so the judge will read that to the jurors and tell them, don't do that, But, again, it's human nature, right? People can do whatever they want. So the important thing is just to do the jury selection. Because if somebody can't be fair toward a plaintiff because of their Middle Eastern heritage, then that person should not be on the jury. And that is somebody you can get off for what's known as cause. And you have unlimited cause challenges. So a good lawyer should be able to just get all those people off. Okay, the next question. The next question is from, let's see. Okay, from AMC Flight Attendant. Closer to the moon. Let's go. Hello. Thank you for your incredible videos. You provide excellent information. Oh, thank you. Thank you for watching. I actually texted you info about my accident with a company car. 8 MRIs, herniated discs, torn rotator, recommended cervical fusion, and disc replacement. Was wondering what you think the worth is. Also, are you able to ask for more than the policy limits in your demand letter, or must you actually file a lawsuit in order to obtain the umbrella policies? What does that entail? Thank you again. You rock. Oh, I like this person. Okay, she or he is very nice. Okay, and they like our videos, which is awesome. So yeah, so I think like to answer that question, I think the main question is asking, can you obtain more than the policy limit in your settlement opportunity or demand letter, in your claim letter, without filing a lawsuit? And the answer to that should be yes, but in practicality, because I think the person wants the practical, pragmatic answer, I would say it's unlikely, because if you write just a letter, or if your lawyer writes a letter and you're dealing with, let's say, a company car, and they disclose the policy limit, maybe they disclosed a $250,000 limit, and then you write them a letter and you're not even in a lawsuit stage yet, and you say, I want $1 million, it's unlikely they're just going to tender that, even if your injuries are very serious. Here, there's no mention of any surgeries. It's just MRIs, herniated discs, recommended fusion, but no actual surgery. So I doubt if they would just tender something like even $250. They might not tender that. So what I would recommend in a situation like that is also like what I was saying before. I would speak to like a local attorney, file the lawsuit. Once you have the lawsuit, now you're entitled to make a demand for the primary policy, as well as any excess, umbrella, supplemental, concurrent, or any other policies that you have other than the primary policy that you already told us about, right? So you got the primary one, 250 or whatever it is, 500, $1 million, and then what are the other ones? And then tell me all of them. And now also, there's a new law in New York where the defendants have to tell you all that, even without you asking. So that's very important. I would get all that. Now, once you have all that, then you can send what I would call a settlement opportunity letter. And you could say, look, we now know that the total amount of coverage you have is $3 million. please tender the $3 million because I'm going to have 2 surgeries. I'm going to have a fusion and a disc replacement procedure, plus I might need a torn rotator cuff surgery. Tender the $3 million, pay me everything, or give me a good faith offer against my request for the full policy. And if you don't pay it, then if I go to court, we're going to be requesting much more, like 8 million, 10 million. And now they're scared, right? Because if they don't pay you something reasonable within the policy could be open and you can go for more. Now, different states have different rules about that, so it matters where you are, but that's why it's also very important to hire a local lawyer. So I hope that was helpful. So it's a good question, but yeah, I've never really seen carriers tender excess just in a claim letter. It's pretty much unlikely. Okay, the next question is from B. Prave, and he or she asks, what if I have my surgery 3 years after the accident? The person that pulled out in front of me, I already had a fusion. It sent me back to severe pain. I just had a micro discectomy, laminectomy, L5-S1. That's the last, the last disc, the sacral, the first sacral. So that's the very last disc in the spine, the L5. I'm in North Carolina. My attorney says she's only asking for $150,000. The attorney for the driver's insurance company offered $10,000. I said, no way. I think I need a different attorney. The guy was driving a company truck. I lost my job and had to sell my home. I went from a good job, beautiful home, to homeless. I finally had to start spending my savings from the house to get off the street. COVID hit next. I don't know what to do. So yeah, that's like a really sad story. I'm really sorry to hear that. That's just terrible. But I would definitely, if you work with your attorney, or if you're not comfortable with your attorney, you can find another attorney, do a little research. You could text me. I could help you find someone. I know a few good attorneys in North Carolina. What I would recommend is, find out the total insurance available, and then you can make a settlement opportunity letter, or if they don't want to pay, then I would just prepare it for trial. But, having surgery, I think talking about having surgery 3 years later, I don't really see it as a problem, because as long as the injury is there, right? Like, for example, you have the crash and then you get diagnosed with an injury a few weeks later by MRI, you have that injury. So then you're getting treatment for that injury. You're seeing chiropractic, you're doing physical therapy, you're doing range of motion, you're doing electrical stimulation, whatever the doctor recommends. Then next, if that doesn't help after like 6 or 7 months, you do, like, say, epidural injections. If that doesn't help, you do the next step, like a percutaneous discectomy, an ablation, whatever, radiofrequency ablation, whatever, some people do rhizotomy, whatever the doctors recommend. You're just listening to the doctors, right? And then maybe 3 years goes by, you might have some breaks from the treatment, but then nothing is helping you. You're still in this pain. So now what do you have to do? You have to do the full-blown surgery, like the discectomy, laminectomy. So that's fine. I don't really see that as a problem. I don't know why they're only asking for $150,000 though. That seems kind of low. I don't know what the policy is, and I don't know why they would only offer $10,000. And when he says the driver's insurance, I'm not sure if he means that's the only insurance, the only, because he was hit by, I believe he said he was hit by a car. So is that the only insurance involved? Or are there multiple insurances? Because sometimes there could be like an insurance for the operator, but a different insurance maybe for the company, for the owner. So it's a little bit, involved here. We need to learn more. But definitely sounds like a case of merit. So I would definitely pursue it. And if your lawyer doesn't have confidence, if your lawyer just thinks it's worth $150,000, maybe speak to someone else. Get a second opinion. It doesn't hurt. Your lawyer may be right. It might not be worth more, but your lawyer may also be wrong, and you might be able to get much more, because in my experience, I'm not really familiar with values in North Carolina, but in New York, something like that, a discectomy, laminectomy, that's worth much more than just $150,000. Okay, the next question. Let's see. Mostly people commenting about their case or about how they're doing. There was one with the Amazon hit and run, laminectomy, discectomy in Boston, Massachusetts. I do know some excellent lawyers up in Boston. Another one was asking about Boise, Idaho. I'd have to do a little research. I'm not too familiar with Boise, although there's going to be a Trial Lawyers University seminar coming up, and I believe there are some lawyers coming from Idaho, so maybe I could reach out to them and speak with them to answer this person's questions about Idaho. And then what is the next question? Okay, here's a question from Michael M. Quick question. California case, premises liability. I am a plaintiff with counsel. After 3 years, we filed and we got an MSC. I think that's a motion for summary judgment, maybe? I'm not sure. I'm not too familiar with California. Oh, I saw. I think he means maybe a trial date for July 20th of 2023. There are 4 defendants. I just noticed one of the defendants filed a motion to leave to file a cross complaint with a court date of 7/18/23, just a couple of days before trial. Is this a common defendant move to delay the trial? What would be the reasoning for such a motion? As always, thank you in advance. So yeah, so basically like the way it works with cross complaints and counter complaints. So if you sue someone, right, you're suing, let's say 4 different companies, and you feel like they're at fault in your premises liability case, whatever it is, like they might have had a hole there, it could have been a ceiling collapse, whatever the premises negligence was. So you're suing all these different, 4 different entities. But they say, wait a minute, there's someone else that's at fault. Maybe there's a cleaning company that's number 5. So then they can then file what's known as a third-party complaint against the other entity, and that'll be a third-party action, and they bring in a 5th company into the case. Another thing they can do is they can file claims against each other. So say there's 4 of them, right? There's number 1, number 2, number 3, and number 4. What if number 4 is like a landlord and he says, you know what, I'm just a landlord, I own this, but you guys were supposed to take care of it. You were the maintenance company, so they can cross complain against. So 4 could say, I'll go against number 2 because number 2 was the maintenance company. They were supposed to take care of this property. They're the property manager. It's their responsibility. I'm just a landlord. I own the building. I could be, out of the country. I could live in Spain and just own a building and make money that way. Why am I liable? I have this property manager. They do everything, right? They totally displace me. They do everything on this property. So that's known as a cross complaint. So basically the short answer is that these defendants feel like someone else may share responsibility. So they want the jury to be able to assign a percentage of negligence to others. So they're making cross complaints against each other. That's a standard thing. I don't know if this is this could be done to delay trial. I mean, usually in New York, when we enter into a preliminary conference order, all the deadlines for third-party actions, cross claims are all in there, right? Here, it seems like it's a little different in California, and they're making a motion to file a new cross complaint now, just a few days before trial. But I don't think if the judge gave you a final trial date, I think that they'll probably just entertain the motion. They could deny the motion. They could allow the motion and say, okay, you have a cross claim, just proceed to trial. It shouldn't really delay the trial, in my opinion, at least, without knowing the case. That's what I would say. My best guess is it should not delay the trial. Okay, the next question is from Collectibles of Texas. I was at a stoplight, and I guess the 18-wheeler missed his turn, so he started to reverse. I tried backing up, but couldn't since there was a car behind me, so I honked and just waited for impact. I required back surgery, got the surgery. Insurance has accepted responsibility for the accident. My lawyer has submitted just medical bills for me and my wife for the $90,000. I have been out of work since the accident and will mostly be disabled as I am receiving long-term disability payments from my ex-employer. I am in Texas. What is the amount the insurance will settle for? Can my attorney ask for $500,000 as I am disabled? Yeah, I mean, like, it's from the sound of that, you're at a stoplight, the 18-wheeler is at fault. You have to find out how much insurance the 18-wheeler has, so your attorney should just send a demand for insurance, like we talked about earlier in this video. Just get all of it, the primary, the excess, depending on, who the owner of the truck is. It could be a large trucking company like JB Hunt, right, or Werner. They probably have multiple layers, much more than just $1 million. So yeah, I mean, something like this, it sounds serious. A back surgery that he's already had. So yeah, I definitely think you could ask for $500,000. You might be able to ask for more and negotiate it and get as much as possible. And it looks like the person said this was in North Texas, maybe somewhere near Dallas. And so yeah, I think that's a good case. They were also asking, do insurance companies already have an amount set aside for accidents? Well, no, they don't really have an amount set aside. They do have something known as reserves, or those could be considered set-asides, but that's mostly for their own protection, right? They just think like, okay, in the worst possible scenario, in the world of worlds, what could happen? Let's say if we have, what's our exposure, right? If this person goes to a jury and the jury believes him and they allow for like, you know, $10 million, what are we going to do? So they have like reserves for each case, but usually it could be limited to the policy unless there's a case of bad faith where you open the policy. So, but that's not the same as the amount that they would set aside to pay you. There's no such amount. You just have to negotiate the case. But the first step I would say is to find out all of the insurance that's available to you. So I hope that's helpful. But that sounds like a very strong case. Yeah, I wish you the best of luck. I think you should definitely win that case. Okay, then we have like a long comment about med mal. I don't think I could read the whole thing, but I think this gentleman is basically saying that a lot of lawyers don't take medical malpractice cases, or maybe there's some kind of issue with the doctors. So he just feels like medical malpractice victims don't get justice. You know, I agree with that in some respects. Like medical malpractice cases are a little bit different in that you have to spend a lot of money as a plaintiff's attorney, right? Like we don't get paid. We just have to spend our own money and our own time. And then the only way we get paid is if we win. But with medical malpractice cases, let's say there's a case where the first thing we have to do is we could review the medical records ourselves. We could speak to the client. Then we have to obtain the medical records, show them to a doctor, pay the doctor probably $2,000, $3,000. The doctor then has to tell us, hey, I believe this case has merit as an expert, as a doctor. That's my opinion. Well, now we can file the lawsuit. If you don't have that opinion, you can't even file the lawsuit in New York because you have to file a certificate of merit that you did that consultation with the doctor. So now you're in court. But for the most part, medical malpractice cases are very hard to settle. The insurance companies will just refuse to settle. And because they're representing this doctor, the doctor doesn't want to have that blemish on his or her license. So they'll proceed to trial. At trial, now you have to call that expert again. The expert has to testify, and you might need multiple experts. So you could be spending $50,000, $100,000 just to prosecute one medical malpractice case. For that reason, it only makes sense to take a medical malpractice case for the most part if it's a real serious, like life-changing, forever injury. If it's just something small, even like somebody had an extra surgery that they didn't need, that's not necessarily a medical malpractice case. It could be. We've had some small ones where it was like, I think during anesthesia, somebody left a little mark, or somebody left, made a small mistake, and somebody needed a surgery because of an error. Sure, you could try those. You could try to settle them. Sometimes they'll pay you $75,000, $100,000. But for the most part, I would say medical malpractice are limited to cases that are 1 million or more. And the other caveat with medical malpractice is in a lot of states, including in New York, what they do is they lower the legal fee because they don't want plaintiffs to sue doctors. They think that everyone's so litigious and everyone's going to go out and start suing doctors, and doctors' insurance rates are going to go sky high. So in order to, what they think is a preventative measure, right, to prevent plaintiffs from suing doctors, what they did is they said, well, look, out of the first, like say 250,000, you can take a third. But if you get more than 250,000, now you're only going to take, let's say, 20%. And if you get more than $1 million, well, now you only get 10%. So it's like a lot of the incentive is gone because now the lawyer is thinking, well, if I get more than $1 million, right, I'm only getting 10%. So to go from like 1 million to 2 million and to really like prep the case and spend more money and spend more time and do these demonstratives, you know, even if I get another $1 million, instead of getting 333,000, which is the usual case with like a car crash, I'm only going to get 100,000, not even half that. So it's kind of like a way that they think, I guess the lobby, and it worked because that's the law now, is to like prevent lawyers from bringing medical malpractice cases. I don't know if it really works. I don't agree with that. I think it should just be a third across the board, but it is the rule. But yeah, but medical malpractice cases can be very, very successful cases if there really is a mistake and if you have a serious injury. So yeah, so I hope that answers that question. Let me see, what other questions do we have here? Here is a question. I previously had a spinal fusion, L5S1, back in 1994. I saw a neurologist in 2018 for some low back pain and right leg weakness, calf numbness. That doctor said the MRI and EMG weren't too bad and not much to worry about. Come back if it gets worse. Never prescribed anything and had 0 treatments. Then in February of 2020, I had a trip and fall on an unsecured carpet in Manhattan. And the pics pretty much prove that they were at fault. And as a result, I had another spinal fusion, L4, L5, in 2020. And what they're basically saying is they're quoting the IME, which is the defense medical expert, and they're talking about that IME. And that IME basically says that the person has adjacent segment degeneration, which is within the natural history of this pathology and known to occur. So I guess what's happening is, even though it's at different levels, right? Back in 1994, the person had something at L5S1. Now the person has something at L4, L5. So, and it's like, I guess their doctor's probably going to say that this L4, L5 injury and the fusion is from this carpet trip and fall. But the defense doctor is being like really kind of sneaky and saying, hey, it's adjacent segment disease. It's a known thing, right? If you have an injury at one segment, you could then have an injury at the adjacent, the very next segment, which it is, right? L4 to L5 years later. And there is literature on that does happen. But I think like if you really do a deep dive and you have to really speak to your lawyer as well as your expert, your surgeon, they should be able to refute, because is it adjacent segment disease or is it traumatic because of this trip and fall? It's either one or the other, and the doctor should be able to give medical evidence as to which one it is. So I don't think you really have to worry about that. And so yeah, that's the question. How much does this previous history, this pre-existing condition affect my case? I mean, it could affect your case a little bit. It could affect your case, especially if the jury buys that argument that it's from the adjacent segment disorder. And it's pretty much like a typical argument, right? In these cases, whether it's just a typical car crash case, personal injury case, it's always the same thing, right? It's like the defendants are saying, this is from living your life, the normal aging process, degeneration, things degenerate. When you live your life, you get older, your spine degenerates, it gets worse over time, slowly, nothing to do with us. Whereas you are trying to say like, look, I fell, I never had this pain before, I was asymptomatic, I was healthy, I was fine, and it was this that caused, maybe I had some pre-existing issues, but it was this fall that caused the aggravation, the exacerbation. It activated something perhaps that was latent, whatever the medical evidence will show. And this is what caused all of it, not anything that I had before. So that's really like an inherent, intrinsic, medical issue that you have to do a deep dive on. I couldn't really tell you without looking at your medical records. Okay, the next question. Who do you have in the Philadelphia area that will go to the end? Okay, yeah, Philadelphia, we do have a few lawyers that we work with that we know. So yeah, feel free to text us and we'd be happy to provide you a recommendation. I would say it really depends on the type of case that it is. There are some lawyers that specialize like in premises cases, like the trip and fall. Other lawyers are excellent just for trucks, right? Trucking accidents, that's what they do. Also depends on the type of injury. Sometimes a soft tissue injury, there are lawyers that are good with soft tissue cases. They either settle them or they're good at taking those to trial, whereas others are specialists in a certain type of injury, like a brain injury. There are certain lawyers that are excellent just for TBI cases. So I want to know what type of case, but I'd be happy to help with that. And then the next question, have you ever done a bus accident case? Maybe do a video on bus accidents. Yeah, absolutely. In fact, we did one earlier, I believe it was earlier this week. We did one on bus accidents. And I think we had some other videos before about bus accidents or bus accident case stories as well. But that's a good topic and we'll definitely, we'll be posting that video. And then the final question, do you, being in New York City, I think you should have a video strictly for cases that are against the city of New York. I was struck by an FDNY EMT van in the Bronx. We are very early in the process, but I am curious on how a lawsuit versus the city is different from a standard lawsuit against car insurance. Yeah, also, I agree. That's a good topic for a video. I'll do a deep dive. I'll do a video about that We have had some videos in the past that we've already posted about New York City cases. The big difference is with New York City, you have to file a notice of claim. So if it's the FDNY, you have 90 days from the date of incident to file a notice of claim against the city of New York, because an FDNY vehicle is like one of their agencies. And then they could do a 50H hearing before you even file a lawsuit, like a pre-lawsuit hearing, which is like a deposition. Usually it's short, but now sometimes, depending on the case, they can hire a law firm and it could be a longer hearing. Then after that, you file a lawsuit. It pretty much is similar, the process. You might go to a city part in the Bronx, which is a little slower than being in a private part where you are able to sue, you know, an insurance. And insurance also tends to settle for higher amounts because it's private insurance, whereas when you're dealing with the city, they might offer you lower amounts depending on how bad the injury is and how serious it is. Although the city does settle cases sometimes, and sometimes they have been fair. And then what I've noticed with the city is like when you show them that you're not afraid to go to trial, you pick a jury, you start. If the trial is going well, at that point, like during the trial, you could settle with them. Like we had, I think, 2 different cases where we settled them for about $1.5 million each during trial with the city. Whereas one of the cases before trial started, they were offering, I believe, like $200,000. And the other case, they were offering 0. They said it's not a case. So it was actually it was a tough case. It was a premises case. But yeah, so you could definitely get money from the city. But if you're going for a big amount, like 7 figures, you may have to go the distance and go to trial. Okay, I hope this has been helpful. Let us know what other questions you have. I like doing this series because I really feel like this is what you want to hear about. These are the questions you're asking, and I want to respond to you directly. Okay, have a great day. Have a great weekend, and we will talk to you very soon. Bye-bye, everyone.